Hi folks, and welcome back to Contract Law. This is video 2 in the series on privity of contract. And in the last video we had a little look at the general rule of privity and its interrelationship with the doctrine of consideration. And we had a look at a few cases, and I introduced the Trident and Whitney case, and now we get to unpack the Trident and Whitney case. Well, as I said in the last video, the Trident case is probably the closest case that we've had in which the High Court balanced precariously on the knife edge of abolishing the doctrine of privity. It was a 4-3 decision of the High Court, so we didn't quite get over the mark there with that one. It has been called somewhat of a mess, and when you have a look at the case, it's not that hard to see why. It has been said that there's almost no real ratio to this case because most of the judges came down with the same result, but following various different principles of law. So there's not a whole lot to come out of it except that it's a masterful piece of work in demonstrating judicial inventiveness and the various different ways that can be found to circumvent the whole doctrine of privity.
Ice this deadbeat!
So the facts of the case are actually quite straightforward. Blue Circle Southern Cement owned a cement plant. It had an insurance contract with Trident Insurance that covered not only Blue Circle but its subsidiaries, contractors and suppliers and so forth in respect of liability for personal injury. Blue Circle had some construction work done at the cement plant. McNeese was its principal contractor, and poor old Mr. Hammond unfortunately suffered a personal injury essentially due to McNeese's negligence. So obviously McNeese sought an indemnity from Trident under the insurance policy between Trident and Blue Circle. Classic case, contract between Blue Circle and Trident, and it's purporting to cover McNeese's conduct, McNeese then seeking the benefit of that insurance policy, seeking to enforce the benefit of that insurance policy. Trident says, hang on a minute, sorry, doctrine of privity, McNeese isn't a party to this contract, so we're going to deny liability there. It goes all the way up to the High Court, and McNeese was actually entitled to the indemnity. So as I said, everyone came down on the side of, indemnities being granted, and McNeese was successful, but so many differing opinions here. Probably the two clearest judges, the joint judgment of Mason and Wilson, was the one that really talks about abolishing and totally reconsidering the doctrine of privity. Gordon is a little more equivocal, and she based her decision allowing McNeese the benefit of this indemnity due to the principle of unjust enrichment, and we'll be covering that in a later video series. Tui agreed that we probably should abolish the doctrine of privity. He says, hey, hang on, it's only about 120 years old at that point, and so it's, it's fairly young in the grand scheme of contract doctrines, so, it's not that entrenched that we can't change it. However, he ultimately bases his decision on this notion of focusing on the way that third parties order their affairs in terms of insurance contracts. Gore gives quite an interesting potted summary of his decision. Brennan, Dawson and Dean essentially they dispute the fact that the doctrine of privity should be abolished, and in fact they say, contra to TUI, that they think the doctrine's so well entrenched that getting rid of it's going to cause just as many problems as hanging on to it and trying to deal with it. So lots of splits in that particular bench in the Trident case. Didn't get over the line. We still have the doctrine of privity with us. So what do we do about that? What is the best way that we've found so far to get around the doctrine of privity? Well, perhaps because I'm a Queenslander and we have this legislation, the best way around it obviously is legislation, and the place to start here is the Property Law Acts. Now, the Property Law Acts, as I just said, there's one in Queensland, there's also one in the NT and WA. WA led the way in 1969 and Queensland followed in 74. Northern Territory were the latecomers in 2000, and unfortunately for everyone else, you guys are all still subject to the whims, the slings and arrows of the common law and doctrine of privity. So it's worth exploring in some depth how the Property Law Acts go about achieving their rather neat and rather simple abolition, effectively, of the doctrine of privity. If you have a look at Section 55 of the PLA, a promisor who, for a valuable consideration, moving from the promisee, promises to do or refrain from doing an act or acts for the benefit of a beneficiary, shall, upon acceptance by the beneficiary, be subject to a duty enforceable by the beneficiary to perform that promise. Yes, folks, Party C can enforce promises made by parties A and B. Okay, let's talk about terminology. So first of all, the promise. The promise obviously has to be justiciable. It has to involve intention to create legal relations. The Property Law Act was never meant to circumvent the doctrine of privity, if it would ever apply in an informal sense to informal promises. You have to have a legally enforceable promise that we're talking about here by one of the parties to benefit this third-party beneficiary. The third-party beneficiary gets the promised benefit. Okay, so 55(1) is all about benefits. The promise must involve a benefit. Can you also bind a third party to undertake a burden or a duty? The answer is only in a very limited sense. Because the promise has to involve a benefit, if there is a burden bound up with getting that benefit, then to that extent you may also, as a third party, have to undertake burdens as well as the benefit. You undertake the burden to get the benefit most of the time. Okay, so 55(1) says a beneficiary can enforce a promise to do or refrain from doing an act or acts for the benefit of a beneficiary. That's the benefit part. Then 55(3)(b) says the beneficiary is going to be bound by the promise and subject to a duty enforceable against the beneficiary in the beneficiary's own name to do or refrain from doing such act or acts, if any, as may be by the terms of the promise be required of the beneficiary. Okay, and so, for example, you've had cases, for example, getting the benefit of mining tenements. If that involves having to pay for the tenements, then that's what you need to do. So you as a third party, you certainly can enforce promises made to benefit you, and if there happen to be burdens or duties, obligations bound up in that promise that will ultimately benefit you, then you're going to have to do those as well. Who is the beneficiary for the purpose of the legislation? Because obviously that's going to be all important. Obviously that's start at the very beginning. Like I always say, a party, if they are named in the contract between A and B, if A, Bob, and B, Mary, make a contract together and name Sue Ellen, party C, the third party, then obviously under Section 55, Sue Ellen is going to be able to sue to enforce the benefit of promises that are made for her. Trickier question is, what if the contract between A and B doesn't expressly name Sue Ellen at all? Now, there's a couple of different options as to what might happen here. You might have, as we saw in the Trident and Whitney case, you might have the contract mentioning a stack of kinds or classes of people, servants, agents, employees at common ones, contractors, subcontractors, and that kind of thing. If that is the case, normally not such a problem. The Bell Group and Westpac case is an example there. The trickier situation, so far as the third party is concerned, is where they're just not mentioned at all. Here you have some fairly different points of view as to whether they should be covered. So in the Northern Sandblasting case, that was a High Court case in relation to the Queensland legislation. You had a landlord arranging for some repairs of a defective electrical appliance. The electrician did the work negligently, and that resulted in a hazard, electrical hazard. The tenants moved in. Their daughter used the electrical appliance. Now, their daughter was on the premises as a permitted tenant, so the landlord knew that she was going to be there, used the appliance and suffered some rather nasty permanent and disabling injuries. The question, one of the alternative bases that was argued there on behalf of the daughter was Section 55. Can she enforce the benefit of the promise in the main contract that didn't mention her? Justice Kirby, there were only a couple of judges that considered that issue. Justice Kirby said yes, the daughter should be able to enforce the benefit of the promise that would assist her in those circumstances. Chief Justice Brennan was very firmly against that whole idea and really tended to stick to this whole notion of, if you're not actually mentioned, you're a true third party, and there is no beneficiary. There's nothing to which the promise can attach, because there's been no contemplation of a third-party beneficiary in the first place. Again, that kind of view was taken by the High Court in Jones and Bartlett. Now, this was not on the Queensland legislation, this decision. It was based on the West Australian Act. However, the court came down very firmly, and this was a full court of the High Court decision here, 5-2, and the court said there that you needed identification of the plaintiff as a beneficiary. There had to be some contemplation of a third-party beneficiary in order to have the provision to work as the legislation intended. So there, I guess, is your chink in the armour of the legislation that itself was a chink in the armour of the doctrine of privity. If you are a third party, you're not mentioned at all by the original promise, then Section 55 is not going to help you out. Next, we have the notion of acceptance. This is a crucial step that has to be undertaken by the third-party beneficiary that seeks to rely on Section 55. The promise benefit will become enforceable upon acceptance by the beneficiary. It has to be by, under 55(6), words or conduct communicated either by the third-party beneficiary or on their behalf. So you can get someone else to do it for you. To the promisor or to some person authorised on the promisor's behalf. So again, it doesn't have to be directly between the beneficiary and the promisor. You can get other people to communicate the acceptance and receive the acceptance on your behalf. The communication of acceptance has to be in the manner and time, date, so forth, as stipulated in the promise, or otherwise it has to be within a reasonable time. Interestingly, you can accept the benefit as a third party. You can accept the benefit of a promise that's going to be made in your favour in an anticipatory sense. So before the promise has even been made in your favour, you can go ahead and accept the benefit of that baby whenever it gets born. Hyatt Australia and LTCB is the case there. That then, acceptance, locks down the situation, and after acceptance, variation and or discharge of the promise itself can only happen with the consent of both the people involved, the promisor and the beneficiary. So that is the scheme of the Property Law Acts, Queensland, Western Australia, Northern Territory. Jolly good little piece of legislation, that one.
And there was much rejoicing.
And that, I think, will wrap up our second video. And we'll leave it here. We'll come back for video 3 in the series on privity of contract. Bye for now.